diving into a full-on masterclass about how the world's largest democracy actually handles the dissolution of a marriage. We're zeroing in on the Hindu Marriage Act of 1955, which governs the vast majority of the Indian population. I mean, we're talking about laws that directly affect the lives of over 1 billion people. We're going to explore this really fascinating tension between preserving an ancient, sacred institution and addressing the modern, often messy realities of irreparably broken relationships. Okay, let's jump right in.
So here's our syllabus for today's masterclass. We'll breeze through 6 modules: the legal foundation, the 1-year bar, mutual consent, the cooling off period, waiving the rules, and finally, alternative dispute resolution. We are mapping out the entire journey from the rigid letter of the law to these much more modern humanitarian solutions.
All right, Module 1, the legal foundation.
We've got to start with the core premise governing family law for the majority of India under the 1955 Act. See, unlike some systems where marriage is just viewed as a straightforward civil contract between 2 people, Hindu law traditionally sees marriage as a sacred, permanent sacrament. It's really viewed as this unbreakable spiritual bond. And because of that, there's a massive legal and social emphasis on preserving the institution. The law is literally built from the ground up to protect the marriage first and foremost.
Just to put the scale of this into perspective, India has a sprawling legal infrastructure with nearly 15,000 courts across the country. That is a lot of courtrooms. But ironically enough, the ultimate goal of Indian family law is actually keeping families out of them. The whole system is designed to avoid that bitter courtroom battle whenever humanly possible.
Which brings us to Module 2, the 1-year bar.
So, to stop couples from just storming into those thousands of courts after one really bad argument, the law throws in a massive speed bump. It's Section 14 of the Hindu Marriage Act. This is a statutory bar that explicitly prevents courts from entertaining any divorce petition within the very first year of marriage. It acts like a mandatory, hard-stop cooling-off period right at the start. And the legislative intent here, it's not just procedural, it's deeply sociological. It's meant to give couples a real window to sort out temperamental differences and genuinely adjust to married life before just pulling the plug.
But, what happens if waiting that year literally causes unbearable suffering? Well, the law isn't completely blind to extreme situations. It gives us a very strict, highly specific exception to bypass that 1-year bar. If the person filing can prove exceptional hardship or exceptional depravity, basically meaning the suffering is so severe that life is unbearable or some grievous moral offense happened, then the court can step in and grant permission to file for divorce before that first year is even up.
Moving right along to Module 3, mutual consent. Okay, let's say a couple has actually passed that 1-year mark, and they both completely agree that the marriage is irreparably broken. Section 13B of the Act is the legal pathway here. Brought in by a landmark amendment in 1976, Section 13B allows for divorce by mutual consent as long as the parties have lived separately for at least a year. This was a real game changer. It represented a pragmatic realization by the legislature that forcing unwilling partners to stay married serves absolutely zero constructive purpose. It really just prolongs the pain.
But as we'll see in Module 4, mutual consent isn't exactly an overnight thing either. Let's look at the cooling-off period.
Because even when both parties agree to part ways, the law still pumps the brakes. Here's how it works. After a couple files their first joint motion for a mutual divorce, the court essentially hits the pause button. The couple has to wait a minimum of 6 months, but no longer than 18 months, before they can even file the second motion to get the divorce finalized.
So why enforce yet another waiting period? Well, as Family Court Judge Parul Gairola laid out in her presentation, this 6-month stretch serves a few absolutely crucial functions. It gives the parties time to change their minds, time to maybe forgive and forget, and most importantly, time to deeply think about the long-term consequences of a divorce, especially when kids are involved. The goal isn't to trap people in a doomed marriage. It's really just to prevent a hasty, emotionally driven mistake.
All right, let's jump into Module 5, waiving the rules. This is where things get really fascinating in practice.
We're looking at this incredible tension between the strict letter of the law and the messy reality of human relationships. On one side, you've got the rule, these mandatory statutory waiting periods perfectly designed to preserve the institution of marriage. But then, on the other side, you've got the exception, the judiciary's power to actually grant waivers. They do this to prevent prolonged, pointless suffering when a marriage is clearly and irreparably broken.
And this exact tension came to a head in the landmark 2017 Supreme Court ruling Amardeep Singh v. Harveen Kaur.
Guys, this was a massive shift for Indian family law. The Supreme Court established that the 6-month waiting period in Section 13B is actually directory, not mandatory. What that means is courts are fully empowered to waive that 6-month period entirely if there is zero chance of the couple getting back together. It lets them just move forward with fresh rehabilitation instead of sitting around in legal limbo.
Now, judges don't just hand out these waivers arbitrarily to anyone who asks. They use a very strict checklist. Before waiving that cooling-off period, a judge is going to look closely at the length of the marriage, exactly how long the couple has been separated, the duration of any pending litigation, and if there's even a shred of possibility for reconciliation. Crucially, they absolutely have to ensure a genuine, rock-solid settlement has been reached between the parties regarding things like alimony and child custody.
And this jurisprudence is constantly evolving. Recent judgments out of the High Court of Delhi have clarified these judicial powers even further. They've actually established that in the right mutual consent cases, courts have the power to waive the 1-year bar for filing and the 6-month cooling-off period simultaneously, literally at the same time. If a marriage is completely broken from day one and forcing them to wait only creates more misery without any gain, the courts can say, okay, we're granting a waiver so you can both move on immediately.
Which brings us to our 6th and final module, alternative dispute resolution.
Remember those 15,000 courts we talked about earlier? Well, despite having all of them, the Indian legal system places a massive and honestly growing emphasis on keeping couples out of formal litigation. They heavily rely on localized mediation and systems like the Lok Adalat. Translating to People's Court, this is a completely non-adversarial setup based on Gandhian principles. It focuses strictly on informal settlement. It treats a family conflict not like a war that needs to be won, but as a human problem that just needs to be solved.
In fact, the law flat out demands this kind of approach. Under Section 23(2) of the Hindu Marriage Act, it's actually a mandatory statutory duty for the court to attempt reconciliation in the first instance, before they even think about granting any relief. The huge takeaway here is that family disputes in India are fundamentally viewed as societal problems that require compassionate, humanitarian resolutions. They actively use counselors and trained mediators to really bridge that communication gap.
As we wrap up this masterclass explainer, I really want to leave you to ponder this core tension. Does a mandatory waiting period genuinely save a marriage, or does it just prolong the inevitable? How exactly should the law balance its duty to preserve an ancient, sacred institution against the very real humanitarian need to let people move on with their lives? It is an incredibly delicate balancing act, and it's one the Indian legal system navigates every single day. Thanks so much for joining me, and I hope this gave you a clear, structured look into the complex realities of dispute resolution in Indian family law.